DIY second marriage inheritance issues. What kind of things do we run into when people do their estate plans themselves? I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. And here are a couple of the things that I see quite a bit. And the first one is not considering a prenup. Of course, a prenup does many things, but it doesn't mean that you don't love someone. It doesn't mean that you don't trust someone. It just sets some expectations. And from an estate planning and inheritance expectation, usually what it says is, my stuff is my stuff, your stuff is your stuff, and we don't have claims on each other's stuff when we die. Now, this does not mean that you cannot leave things to your spouse in your will, but it does mean that they can't grab pieces of it that you didn't intend for them to have, because we've got the prenup that says legally you can't do that. You have waived your right to do that. The next issue with DIY second marriage inheritance is forgetting to update those beneficiary designations. If they have not been updated since your first marriage, if they have not been updated since your children became 18 or older, if they haven't been updated to reflect trusts that you've put in place or anything else that has changed, it is likely to throw your plan completely off kilter. The last one that I see, and this one causes a lot of friction, is leaving the new spouse in control of money for children from your first marriage. You love your new spouse. You trust your new spouse. And sometimes it has been an incredibly well-blended family. Your kids get along with your spouse. Everyone is very happy. But often it leads to a lot of friction when someone who is not my parent is in charge of the money that my parent left for me. And there can be questions about, are we trying to save this money for the spouse? Are we trying to, when should the children get it? And we want to make sure that if you leave someone in charge of money, it's someone who is well positioned to be fair to everyone. So you are often not going to want to leave your second spouse in control of money left for children of your first marriage. That can cause tons and tons of issues. If you have more questions about beneficiaries and other inheritance issues with a second marriage, I would love to answer them. And please feel free to also comment. Thank you.
What happens to a living trust in case of a divorce? I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia, and author of the book, Peace of Mind Through Estate Planning. If you've been married, are thinking about getting married, are considering putting together a trust, there are lots of times that you might want to know what happens if there's a trust and a divorce. First of all, we will set the expectation that this is a living trust, which means a trust that is set up during a lifetime. Sometimes there are testamentary trusts, which is a trust inside someone's will, but it has not sprung into being until that will has been probated. So we are only talking about trusts set up during someone's lifetime, which could be a trust that I set up for myself, or could be a trust that someone else sets up for me. And that is going to be one of our key questions. Who set up the trust? Where did the assets come from? And there are differences between assets that I might put in trust for myself and assets that someone else might gift me in trust. So generally speaking, if someone else puts assets into a trust for me, either as a gift or an inheritance, that can be separate property. There are some caveats to that, of course, and one of those is specifically that it has to be kept separate. So if I inherit assets, even inside a trust, and I intermingle them and put some things from the trust into, say, my personal bank account, and then use money from personal bank account to make repairs on the house in the trust, and generally just intermingle funds. If I have not kept this separate and I'm going through a divorce, this trust might be considered marital property. There are a lot of specifics to every case, so this is just a generalization. But another question, as we're trying to decide, is it marital property or not, is when were the assets put into trust? And generally, if they were put into trust before the marriage, there is a greater likelihood of it being a separate asset that the divorce cannot touch than if it was created during the marriage. Along the lines of, reiterating intermingling funds, we really have to keep anything separate. Does not matter who, does not matter when. If it is not kept separate and apart, if it is intermingled with other marital assets, there is a really good chance that it ends up being a marital asset. And then, of course, is the question of debts. Georgia is a very creditor-friendly state, and it does not approve of the idea that I can put my money into a trust and then say, haha, I cannot pay my debts. Creditors are out of luck. So in Georgia, if I put my money into a trust and a creditor comes knocking, they are still going to ultimately be able to access those funds. In a divorce, your soon-to-be ex might be a creditor. There might be child support or spousal support or other debts. And so if you have created the trust for yourself, Georgia does not approve of you trying to avoid those debts. There are other states that have asset protection trusts. Georgia does not. And so you could definitely look at an out-of-state or offshore trust if that was something that you are interested in. But here in Georgia, you are not going to be able to avoid your creditors with your money just because you placed it in trust. So there are a lot of fact specifics, but these are some of the issues that we look at when we try to figure out what happens to this particular trust in this particular divorce proceeding.
DIY mistakes for wills dealing with blended families. What common issues do we see? I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. And common problems with do-it-yourself estate plans, and particularly with wills for blended families. So the first one is that it is a will. With a blended family, you want to strongly consider a trust. A trust makes sure that whatever you are giving goes to the person it is supposed to go to. Because often with a blended family situation, the goal is to take care of the spouse during the spouse's lifetime, but then make sure whatever you owned goes to your children, and whatever they owned goes to their children. So we have sort of a competing goal of leave money for spouse and make sure nobody changes anything so that whatever's left over goes to my children. With a will, if we leave the money to spouse, and of course, we sat in the office with the attorney and the spouse made a will that reflected our will, and we both, evenly split up things between our children, so whoever's left is going to be super fair. And we want to believe this, and I want to believe it for you. And sometimes it is true. Other times, after you have passed away, your child is rude to your spouse and gets cut out of the spouse's new will. It's not what you would have wanted. Of course, you didn't want conflict in the family either, but having a will instead of a trust, which the trust cannot be changed by anyone other than you, so once you've passed away, you know that it's set in stone. Having that will is a DIY mistake. We really strongly want to consider trusts. Another mistake is not really thinking through and having a practical plan for dealing with the house. Because along the same lines as the first mistake, we want spouse to be able to live in the house for as long as necessary and then have that house go to our children. How long does spouse keep it? What constitutes living in it? Are we having, if the spouse moves to an assisted living home and can no longer live in the house, is it now the children's, or does it wait until after the spouse has actually passed away? What are the parameters around this? Who decides? Who's paying for the upkeep? Where's that money coming from? All of these things are easily messed up because they're very complicated and very situation specific. So not having a practical plan for how to deal with the house is a big DIY mistake with wills. The other one that really comes to mind is not talking to your family. You want your children and your spouse's children, and perhaps, the children that both of you have, whichever members of this blended family exist, you want to have a conversation with all of them where everyone tries to get on the same page, maybe not agreeing with your plan, but at least understands what it is you're trying to accomplish. And that can very much help relieve friction if your children and your extended children understand the goal of taking care of spouse and then leaving things to children, and that you are attempting to be fair and loving to everyone. Now, people will always fight, and blended families can be more difficult sometimes than other families, but sitting everyone down and communicating expectations is key. So these are some top DIY mistakes for wills and blended families. If you've got more questions about this or have a blended family and need to do some planning, I would love to talk to you, and I also welcome your comments. Thank you.
In this video, we're going to discuss when you should update or consider updating your estate plan. I'm attorney Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. And I'm going to tell you about 7 times that I think you should consider updating your estate plan. And so the first one is if you got married. So it's incredibly important to understand that if you have a will from before your marriage, as soon as you get married, that will is completely messed up. It's not entirely revoked, but the court assumes that you forgot to change it, and so, the new spouse is getting, no less than a third, depending, maybe more, depending on whether there are children, and so it's completely messed up. So, if you've gotten married, update your estate plan. If you've gotten divorced, update your estate plan. So, if you have an estate plan that happened during marriage, when you get divorced, the court assumes that you no longer want, your ex-spouse to be acting as your executor, and so proceeds with pretending that that person has passed away, and everything sort of occurs as if they have already passed away. And so this is not quite as bad as what happens if you get married after a will, but it can cause a lot of problems, and it does not fix beneficiary designations. So beneficiary designations on your life insurance, on your IRA, on your whatever, if those don't get updated, it's still going to the ex-spouse. So, as part of your whole estate plan, these are things we need to look at. Birth of your first child. This is another time that we need to look at updating our estate plan. Also a time when the court assumes that unless you can say in your will, in your trust, that this was done in contemplation of children, contemplation of more children, and then it will stay. But usually the court assumes that you, again, just forgot to update and you would have wanted them to get a share, and sort of rewrites it for you. The next time is when you have more children. So subsequent children, and this may not be a time that you actually need to update it. what you need to do is check and make sure that the wording is correct. Because we're going to have a problem if it says everything to child 1. Then the court's going to get involved and rewrite things. Because again, they assume that you really meant to include child 2 and you just didn't get around to it. On the other hand, if you look at your documents and they say, equal distribution between, child 1 and any subsequent children that I have, you're good to go. We've already covered, and the court can see that we have, prepared for any subsequent children. Another time that you really need to look at your estate plan and definitely need to update it is changes in relationships with the important people, the person you've chosen as trustee over money, the person you've named as executor, the person you've named as your power of attorney if something happens to you. If these people are no longer close to you, maybe you're no longer friends at all, or maybe they've moved away out of the neighborhood or out of state, they wouldn't really want to do the job, you want to choose someone else. Don't leave that to chance. Don't wait. Go ahead and update it. The same thing if they've actually passed away. When someone important in your plan passes away, whether that is, someone who you've chosen as, executor, trustee, whatever, or a beneficiary. If an important beneficiary passes away, we want to rewrite, make sure that the correct person is inheriting whatever it is that they were going to inherit. Do we just want it to go straight to their kids? Is there someone else that, did they have kids? Is there someone else that we want it to go to? And then the last big one, and I do say big one because, much like marriage, creating a blended family, and it's might even be considered a subset of marriage. But when you create a blended family, it's not just as simple as what is new spouse going to get. We have to think about my children, your children, our children, who's getting what, under what circumstances. How do we make sure that what we've planned stays in place? So those are 7 times that I think you need to either, amend your estate plan, or at the very least go through it and make sure that it's still valid and it still covers the situation adequately. In this video, we are going to talk about reducing future conflict in your estate. Hi, I'm attorney Sarah Siedentopf. I practice estate law and probate here in Atlanta, Georgia. So, what things can we do to reduce conflict with your estate? And I feel like it goes without saying, but I am going to say, have a legal will or trust. We are almost guaranteed conflict if there are no legal documents, and again, really like 99% sure of conflict if you leave a semi-legal, non-legal, letter that kind of looks like a will but doesn't qualify. We're getting conflict. Somebody is going to want to go under the terms of your quasi-will, and somebody is going to point out that it's not legal, and we are getting conflict. So make sure that you have a legal estate plan. The next thing is to talk to your beneficiaries. Let them know ahead of time what to expect. It makes things easier when they have heard it from you and have their expectations straight. If you have 2 children and you're not planning on a 50-50 distribution, there may be a reason not to tell them. So I'm not saying that 100% of the time you should be discussing things with your beneficiaries. But if you are thinking about something other than what they expect, talk to them. Explain your rationale. Another thing, make a thoughtful distribution. Thoughtful is not necessarily the same as even, although often it is even, but there are times when it makes sense to leave more to one person for a specific reason. In this case, it is especially important to go back to the previous step and talk to people. let them know ahead of time why you are doing this. It's not because you don't love them equally, but there is a reason. Maybe you made a loan that hasn't been repaid, and so one child is getting more than the other. There could be many, many reasons for a thoughtful distribution that isn't equal, but talking to them ahead of time is super important for reducing conflict. And then, of course, there is the in terrorem clause. This is something that you add to your will or your trust, and it basically says, if anyone tries to contest this document, they don't get whatever they were supposed to inherit. And so it is designed to prevent people from contesting documents just because they're mad, because even if you win, you still lose because you don't inherit. So this is not guaranteed, but it's an easy step for put it in the document, and there will be a way to point out, hey, you don't get anything if you cause a problem. And then if you really have an estate where you are expecting conflict, the last thing is you can put a professional in charge. So sometimes, and oftentimes, it makes sense to have your child or your relative or your friend as executor of your estate, as trustee of your estate. They already know you well, they're going to follow your wishes, they're willing to do this thing, potentially not even charge for it. But if you are expecting conflict, having a professional in charge can really cut down on that. They have, been to a rodeo before and have, know about how to properly manage things. They are not able to be accused of favoritism because, it's not like you're favoring yourself because you're inheriting, because they are not inheriting. And if there is some kind of conflict, they are best able to nip it in the bud, get it solved, because they have the resources to do that. So these are my suggestions for reducing conflict in your estate. And if you want to talk about your estate and make plans for the best ways to reduce conflict in your specific situation, I would love to hear from you. And thank you for watching. Please like and subscribe. In this video, we are going to discuss how to handle sentimental items in your estate plan. Hi, I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. The first step is making a list. You have to know what it is that you care about and want to specifically give away. Because we have sort of overarching, so-and-so gets all of my personal property, or, these several people get to split it. But that doesn't account for specific sentimental items that you either want to go to specific people or that you want to shed light on and remind that the rocking chair was built by, great-grandfather so-and-so by hand. Because you know this, but your children may not remember it when the time comes and may not understand that this is an important family heirloom. So the first thing is to make a list, know what it is that you care about, and then you have options. The first option is sort of the most permanent. We can put it directly in your will or trust. We can make a list inside the document that says, so-and-so gets the rocking chair, hand carved by such and such. Or we can say in your will or trust that there is going to be a letter included with the will or trust, and reference the statute, because here in Georgia we have a law which I think of as new, but at this point it's been around for about 3 years, that says if we reference the letter and it's found with the will, it is binding on the executor. So it used to be that we would just sort of say, hey, I have left a letter and I really hope that my executor honors it. But now you can have a letter and it can be binding on your executor. The benefit of this is that when you wake up in the middle of the night and realize that you left something off, you can add it. You don't have to come back to the attorney's office and sign a whole new will with, 2 witnesses and a notary. You can update it. Maybe, you have different pieces of property now, different family considerations, your new grandchild, you want them to have something that, 10 years ago when they didn't exist, you can't give it to somebody that doesn't exist. So that is the second option. Another option is closer to the old way of, hoping that the executor honors your wishes, but it's putting names on things. And I know this is very, very popular with families where, you put a little sticker on something and it says so-and-so's name, and then your executor knows that this person is supposed to get it. This is not binding. There is no law that says putting a sticker is binding. And I have definitely had people in my office talking about, the second wife removing stickers from things. So this one is very practical from a family standpoint because it is easy as you move through your house and as you see something and think of who would treasure it. But from a legal standpoint, it's my least favorite because it's not binding and people can sort of tamper with things. The last option is actually to give things away during your lifetime. There very well may come a point where you are downsizing, and it makes sense to pass the sentimental item on during your lifetime. And this is another way of making sure that there is a legal transfer that, of course, you can't make the person keep the item. So once it has been given as a gift to the next person, they can get rid of it. And that may be something that you don't want to happen until you have passed on and don't know about it. So there are, of course, dangers to giving items away. But this is another way of doing it legally so that no one else can step in and, disarrange your plan. So if you have personal items that you really want to think about, sentimental items, like I said, the very first step is thinking through them and making a list so that no matter which option you choose, you know what things you need to be including. If you do have an estate plan that needs to include some sentimental items, I would love to talk to you. Please give me a call. Also, thank you for watching, and please like and subscribe.